State's Statement of Facts to Court of Criminal Appeals. On July 26, 2008, Mary Grace McNatt married Clarence McNatt, appellant. They remained unhappily married until after the appellant tried to have her kidnapped and sexually assaulted, with their divorce finalized in October 2017. In 2010, Mary Grace met Marivik Milton. They became friends and co-workers. Mary Grace and the appellant were also church members and friends with Edwin Kent. At some point, the marriage between Mary Grace and the appellant began to deteriorate. The appellant started being mean to Mary Grace early in the marriage. Eventually, his anger escalated, and he began asking Kent if his former military ties could connect him with criminals who could kidnap and sexually assault both women. The appellant even expressed a desire to have the women murdered. Kent realized the appellant was serious and told him to write out the information of the people he wanted kidnapped. The appellant did this and also wrote a graphic and angry description of his wife and her friend being sexually assaulted and treated with dehumanizing behavior. Kent turned this information over to the Pasadena Police Department and gave them the appellant's number. The officers then set up 2 meetings with the appellant, pretending to be criminals on November 29th and 30th, 2016. During these meetings, the appellant requested that the 2 men kidnap his wife and her friend Marivik and sexually assault them. At the second meeting, the appellant brought money and rings as partial payment for the kidnappings. He also brought supplies needed for the kidnapping, including condoms, food, dog leashes, and the addresses of both women. Appellant's Statement of Facts to Court of Criminal Appeals. In October 2016, the Pasadena Police Department responded to a disturbance at Edwin Kent's home involving his girlfriend's brother. Although Kent initially called the police about a fight in his front yard, he informed them that the appellant had asked him to find someone to kidnap, sexually assault, and kill his wife and her friend. To support his claims, Kent presented officers with an index card containing the women's contact information, a letter allegedly written by the appellant, and text messages he claimed were from the appellant. The index card and letter were later brought to the police station, but the text messages were never produced as evidence. On November 8, 2016, Detective Christopher McGregor of the Pasadena Police Department was assigned to the case. He interviewed Kent, who provided the index card and letter instructing the hitman. Detective McGregor contacted the Harris County District Attorney's Office and reached out to narcotics officers with undercover expertise to assist in the investigation. The appellant met Mary Grace McNatt through her aunt, visited her in the Philippines, and brought her to the U.S. to marry her. They were married for 8 years, during which Mary Grace described the appellant as mean and accusatory of infidelity. She left him after a suicide attempt in September or October 2016, moving in with her friend Marivik Milton. Mary Grace and Marivik, both from the Philippines, were close friends who worked together at a daycare and later at a bar, often carpooling and staying at Marivik's house due to late shifts. Kent, who met the appellant through church, testified that they became close friends, with the appellant frequently helping him financially and assisting with car repairs. Kent claimed he observed marital problems between the appellant and Mary Grace, including rumors at church and Mary Grace's quiet demeanor. He testified that the appellant had discussed kidnapping, sexually assaulting, and even murdering Mary Grace and Marivik, blaming Marivik for his marital problems. Kent claimed he fabricated the existence of criminal contacts and requested the index card and letter to make the appellant believe his story. Undercover officers posing as hitmen met with the appellant during the investigation. At their first meeting on November 29, 2016, the appellant discussed his plans but avoided explicitly mentioning sexual assault. The officers introduced violent and sexual scenarios to which the appellant gave ambiguous or reluctant responses. At the second meeting on November 30, 2016, the appellant provided $100 in cash, 3 gold rings, and information about the women, including their schedules and locations. Although he claimed to have forgotten additional promised items, such as a gun, the officers interpreted his actions as evidence of intent. Following his arrest, a search of his home uncovered additional valuables not brought to the meeting. The defense argued that the evidence was insufficient to prove solicitation for capital murder and aggravated kidnapping with intent to commit sexual assault, citing the lack of clear remuneration or explicit requests for murder. The trial court denied the motions, and the appellant rested his case without testifying or presenting further evidence. The first and most alarming piece of evidence is that the prosecution has refused to allow the police report to be introduced at trial, despite referencing its context numerous times. They attempt to justify this by claiming to rely on the officer's memory. However, the officers repeatedly state that they are unsure of certain details and would need to refer to the report for accuracy, clearly acknowledging that their memory alone was insufficient. Yet, the trial continued without the report being included. As I scroll through the exhibit list of the court transcript, specifically Volume 7 of the Recorder's Report by Maddie Kimball, it is evident that no police record was introduced into evidence. This is despite the fact that the police report exists and was only recently disclosed 8 years later after I made a public information request. The Pasadena Police Department was notably combative during this process, causing procedural delays to hinder my access to the report. This report is crucial because it allows me to directly contradict and expose multiple falsehoods presented during the trial. To support this, I will include the police report itself, along with a recorded phone call with Pasadena's legal department. In this call, an individual named Mitzi, who works in open records, was evasive about what had been submitted to the Attorney General. I will also include the heavily redacted brief that Pasadena sent to the Attorney General, as well as the Attorney General's response, which ruled that the information should be disclosed. It is worth noting that Pasadena argued that part of my request was non-responsive, leading to my conversation with Mitzi. During this discussion, they vaguely acknowledged finding new information.
Usually was, once you got the redacted incident report was, hey, what's going on with the rest of the information that requested. Mm-hmm. So I had to try to find out, first of all, what you were referencing, and then I sort of clued into what you mentioned, and you were saying, hey, there's all these photos and reports and so forth. So I had to talk to PD about what you were mentioning, because initially what was referenced was, there was nothing wrong with it. So they, some information was found in what you referenced. So what I had to do was talk to the Office of the Attorney General, and that took some time. So there wasn't, I don't even think you all being responded to. I had to talk to, police agency and Office of the Attorney General, because this has never happened before. So I had to find out information before I could just, talk with you and release and so forth. So I talked to the Office of the Attorney General, and because the information, that you requested relied into undercover, police officer information and so forth, what they had referenced is the newly found information would need to be resubmitted to them for, I guess, their review on if what has been found now is releasable or not.
To be deliberate. Pasadena Police Department's arguments. 1. Confidentiality under Section 552.108, Law Enforcement Exception. The department argued that releasing the information would interfere with an active criminal investigation or prosecution. 2. Privacy under Section 552.101. They claimed the records were exempt because they included personal, sensitive details protected under common law privacy. 3. Protection of third-party information. Asserted that certain details were sensitive as they involved third parties who had a reasonable expectation of privacy. Texas Attorney General's rejections. 1. On Section 552.108, active investigation. The Attorney General stated that the police department did not provide sufficient evidence to prove how disclosure would interfere with law enforcement activities. Simply claiming interference is not enough. Specific reasoning and factual support are required. 2. On privacy under Section 552.101. The Attorney General clarified that not all personal information is automatically protected. The information in question was reviewed and determined not to meet the high threshold for privacy protection under common law. 3, on third-party information. The response highlighted that much of the information the department sought to withhold did not qualify as highly intimate or embarrassing, which is necessary for privacy exemptions.